My lord, may I have your kind leave to mention one application, my lord?
Yes.
Appellate side. It's, my lord, under 379 of BNSS Perjury application, my lord, against one top government official who has submitted false information before this honorable court on oath, my lord. My lord, kindly take it up. My lord.
One restoration application. Let's check.
As per your lordship direction, I have
Please give that paper. That one. To be mentioned. Tomorrow it will be listed as to be mentioned.
Your lordship may be permitted to mention a matter mentioning upon notice, your lordship.
Pardon?
This matter, your lordship, the appeal is pending before court 13. Your lordship, that matter has been directed to be listed in the monthly list of September, your lordship. My appeal is pending, and my clients, they have been dispossessed, your lordship. While an order.
Not dispossessed.
Yes, your lordship, the sheriff
But
has
then,
come to the.
see, on the administrative side,
Exactly.
I will be able to do something if the matter is released. As long as it is in the board of a particular court, I can't pull out the matter on the administrative.
Your lordship, but I'm completely remediless, your lordship, because
Then you file an application for appropriate interim relief and mention at least the application, if not the appeal.
before this honorable.
No. Before the concerned court having determination. You
But your
file
lordship,
can
you mentioned several times, your lordship, but
probably the court is not doesn't have time to take up the
No,
matter.
my lord,
Fine.
it's not that. My lord, may I assist your lordship? It is not that. My lord, their appeal. Firstly, my lord, there was a conditional stay. They did not fulfill the condition.
lordship, they are
Thereafter,
extremely poor people, your
my
lordship.
lord,
They are
they
not
wa-
being
they
able to
allowed
pay that
the
amount,
appeal
your
to be
lordship.
dismissed as a strategic dismissal.
No, your
Then
lordship,
they
that
went
is
back
not
to
true.
restore the appeal. The honorable judge said, "I am very well aware what you have done. I will not."
Lordship, they are extremely under a financial
It is
crunch,
not
your
that-
lordship. They are not being able
Then
to
what
submit
you
that
should have
amount, your
done
lordship.
is either you should have sought for extension of time
Yes,
or for modification of the condition imposed.
nothing done.
Pleading inability, financial difficulty,
Correct,
etc. That should have been the proper advice. You please discuss with your senior and take some steps.
I bow down, your lordship. I'm grateful.
My lord, I beg to mention a matter, my lord. My lord, item number 107 of my lord's monthly list of appellate side, my lord. I'm begging for an upgradation. If my lord may be
What
kind
is the urgency?
My lord, the urgency is, my lord, the matter has been filed in 2024, my lord. It has been heard once. If my lord gives us the time of the day, my lord, we can satisfy your lordship and my lord, the matter can be
It
disposed
is a
of.
group 6 matter.
Group 6 matter, my lord.
We heard the matter, is it?
My lord did not hear the matter yet. It was heard by lastly by my Honorable Justice Mr. Arindam Mukherjee.
No.
Tabobatra.
This matter was running before my Lord Justice Saurabh Chakraborty.
Okay.
Thrice the matter was called on. The respondents did not appear. But there was a recording by the honorable judge that if the
All right,
respondents did
next
not.
week we will upgrade. You please give them.
Grateful, my lord.
Yes, please
Great.
call.
Original said daily list matter item number 1, 2, 3.
My lord, I am appearing online, my lord.
Yes, sir. Appeals dismissed.
Deployed.
Item number 4.
My lord, first of all, I am tendering my apology
Hmm.
for my yesterday's conduct, my lord. When the dictation was going on, I had interrupted, my lord. My lord, I subsequently
doesn't
I
matter.
realized my mistake, my lord.
No problem. Yes,
My lord,
you,
263 matter.
you'll take us through the tribunal's finding, or
My lord, tribunal, the assessee had, my lord, claimed that the assessee had furnished all the details before the assessing officer, and the assessing officer, after examination, was satisfied about the claim of the assessee. There are the two properties, my lord. One is leasehold property, another is freehold property. Leasehold property, my lord, these two aspects are important. Leasehold property is situated at Ranjan Gaon, and the freehold property is stated at the Dhok Sangvi village.
yes,
Yes. This leasehold property, my lord, first there was an agreement for sale that was executed on 31st of December 2016.
yes,
Subsequently, deed of assignment was executed on 27th of March 2018. This is Ranjangaon property, my lord. So assessee is saying that since the agreement for sale was executed in 2016, so this is the transfer is not coming within the year under consideration. My contention is that that transaction was completed by way of deed of assignment. Agreement for sale was only the contract to transfer the property, which was subsequently transferred by way of deed of assignment
in
that-
2018.
18. So that is coming within the year under consideration. My lord. And this leasehold property, my lord, that was executed by way of
Freehold.
deed of conveyance.
Freehold,
Freehold, sorry, again, freehold property, the Dok Sangvi, that was a deed of conveyance was executed on 29th of September 2017.
yes,
So this was under this year under consideration. my lord. Here the tribunal held that transfer was about the leasehold property, that property was transfer was made in 2016, so it is not another year. So the section 56 to 10 is not applicable. One,
yes,
second, my lord, the tribunal has held that section 56 to 10 is not applicable in respect of leasehold property.
apart from the fact that it is not in this assessment year, it also held
Yes.
56 to 10 not applicable.
Not applicable, but in respect of freehold property, in this aspect, tribunal has given no finding whether applicable or not. In respect of freehold property, the tribunal has even finding that these properties are for these properties the assessee is getting incentive from the government. There's a Maharashtra financial incentive scheme. There is a 2013 under that, and 100% subsidy is being given to the assessee. So actually there was no benefit the assessee was getting from this undervaluation. One. And the foremost thing, my lord, now the regarding the contention of the assessee, my lord, that the details were submitted before the assessing officer. My lord, kindly see the reply of the assessee, my lord. That is at my lord page 75,
79.
79, my lord, 79. My lord, kindly come to page 81.
Yes.
Paragraph 1.5. The company had also set out the complete facts in the notes filed along with the return of the income, copy of which is enclosed as pages 153, 154 of paper book 3. The relevant extract thereof reads as follows. So, my lord, these are the details that were given to the assessing officer.
Let us go through them.
Yes, my lord.
Yes.
Sir. So, my lord, from it transpired that all the details were not provided to the assessing officer.
Pardon?
All the details, the complete set of details were not provided to the assessing officer. And nor the assessing officer called for any details by supplying questionnaire to the assessing. And this finding was given by the PCIT. The true properties of all these contentions here is only in respect of one leasehold property given in this details, my lord.
But from the assessment order, where is the assessment order?
Page 16, my lord. Volume 1, page 16.
In the assessment order, there is no reference to the valuation.
No.
Only 5 issues was considered by the AO.
5 issues, there were 5 issues, my lord. The PCIT had accepted contention of the assessee in respect of 3 issues. For those 3 issues, no direction was given. Only in respect of 2 issues, direction was given.
Where is the finding of the tribunal?
My lord, the tribunal's order is in volume 2, page 163. Finding starts at one. My lord, 184 page. Findings 184. One point I forgot to mention, my lord. The tribunal has also held that the 263 was invoked at the on the reference made by the assessing officer. So it is the invocation of 263 is invalid. But fact is that, my lord,
Now, in this appeal, only question number 1 alone is challenged. Page 184.
yes, my lord, this starts from for this leave properties, valuation of the property.
No.
My lord.
There are 5 issues the tribunal said.
No,
Your-
5 issues in the original 263 proceedings.
No, you are on appeal only on issue 1.
2, my lord.
Which are the 2?
First is this properties, my lord. There is writing back of provision of for liability under section 43B.
So 1 and 3.
Yes, my lord.
Correct?
Yes, my lord. Yes, 1 and 3.
On this, what is your argument that the PCIT failed to apply his mind?
My lord, the PCIT is given a reasoned order, my lord.
Where is that?
Page 92, my lord. Volume 2. Page 90.
'92 is in volume 2. Yes.
Volume 2, my lord. First. This reasonings is given at, my lord, in respect of this at page 157. Paragraph 6, my lord.
Paragraph
6. Bottom, my
6.
lord.
Oh, bottom. No. The tribunal says
My lord.
at page 185.
My lord.
Therefore, we find merit in the contention of the learned counsel of the assessee
Hmm.
that jurisdiction has been invoked by PCIT at the instance of the assessing officer,
Yes,
which
my
is incorrect and against the provisions of the Act,
Yeah.
and also the ratio laid down by various honorable high courts, including the jurisdictional high court.
lord. My lord, here it was not invoked at the instance of the assessing officer. There was tax audit report on the basis of audit objection. My lord, the matter was referred to the PCIT. Page, kindly see, my lord, page 92.
So he refers to that assessment record. He has perused the assessment record. And who has submitted the audit report? The audit report is a piece of information
My lord.
based on which he has to record independent.
Assessing officer had
For
informed the PCIT.
therefore,
Yeah.
what he has to do, he has to see the report
Yes.
and form an opinion.
Yes, my lord, that was
Does he
that was
form
I'm
the-
showing, my lord. That was I'm showing, my lord.
You please show.
My lord, kindly come to page 92, my lord. First.
Yes.
Yeah. In the instant case, it was revealed from the audit report of para 2 clause 29B that during the year the assessee has acquired freehold land, and the building on Ranjangaon, Pune with an agreement value consideration of such and such stamp duty value. Yes, these are the, my lord.
No.
Right.
He refers
Thereafter,
to the
again, my lord, at page 93. Again, test check of assessment record revealed. My lord, in the
that
fourth
is on
paragraph.
80 JJA.
Yes.
See, first paragraph alone deals with the valuation.
Yes, my lord.
There is no independent application. See, he can peruse the audit report and then he can say that I also saw the assessment files. No notice was issued to the assessee to bring on record any document, etc. And therefore, income chargeable to tax has escaped assessment or something like that. So you see 263.
My lord. My lord, kindly come to page 158 once, my lord.
What is 158?
150 is the conclusion of the PCIT, my lord.
No. The tribunal faults the PCIT for not applying his mind.
Yes, my lord, that was, so I'm trying to show that was PCIT has applied his
That
mind.
could be evident from the show cause notice. He can't improve upon that. What does it say? The principal commissioner, chief commissioner, or principal commissioner or commissioner may call for and examine the record of any proceedings under this Act. And if he considers that any order passed therein by the assessing officer is erroneous insofar as it is prejudicial, he may, after giving a so may call for an examine, and he has to consider that the order passed by the AO is erroneous and insofar as it is prejudicial. That is why the tribunal has referred to two decisions.
Sinotia metals, my lord. Yes. In Sinotia metals, my lord, the facts were a little bit different, my lord. In that, the PCIT had asked the joint commissioner for reference, my lord. Sinotia metals findings are page 186.
So it is evident that the 263 was invoked only based upon the information given by the AO, which is based on an audit report. So what is required is, see, he may forward anything, But this is a very, very, what is a power which has to be exercised in terms of the provisions of the Act.
My lord, their first line is says on perusal of the assessment record.
But the quoted portion,
On perusal.
it was observed. On perusal of the assessment record of the assessee, it was observed. In the incident case, it was revealed that the audit report. This is a piece of information. He can accept it or even reject it. So for which he has to record his opinion. That's what the tribunal says. It has not been done. The tribunal is correct. In fact, in the other decision, Karabi dealers, however, solely based upon the proposal, action could not have been initiated under 263, as the statute mandates that the PCIT should inquire and be satisfied that the case warrants exercise of jurisdiction under 263. Such satisfaction should be manifest in the show cause notice which is issued. However, we find the instant case, the word used by the is prima facie. Sir, this issue was inquired into, sir. You please come to page 194. They have placed all the facts that is extracted by the tribunal. Though the, am I right, sir? Factually.
That was, I was showing, my lord, in the initial stage, I have shown this, my lord.
Correct, sir.
But,
See, the assessment order does not deal with this.
no.
It cannot be your case that this was not examined at all. It was examined and they have placed the entire thing. And one of which is 100% subsidy, that is that freehold land.
For the entire investment.
Entire,
That is
Investment
both
land and-
leasehold,
Yes.
leasehold and freehold.
Entire
100%.
investment, my lord, which I'm.
See, suppose there was an undervaluation. Do you mean to say that the government will accept it?
but these things were not before the assessing officer.
No, it is there. That is
My lord, kindly see, you see, in this, my lord, reply, this, what has been
Sir,
quoted
please,
as 194, my lord.
let us not commit mistake on facts.
My lord, my understanding may be.
Let us read together, page 192 bottom. Moreover, these properties were valued on scientific basis as calculated with the registered valuer, last line.
Yes, yes.
This is Westian so and so. We also note that the property acquired by the assessee was not fully developed and has uneven surfaces, etc. We also note the fact that the acquisition of properties always a valuation report as such was fully placed before the NFAC. We also observe from the facts which are disclosed in the notes to the tax audit report and the notes to the computation of income filed along with the return of income filed before the AO at the time of scrutiny assessment, copy of which is available in pages 93 to 95, which is extracted over the page.
These notes might I had referred to initially, my lord.
Correct.
Before at page in the reply of the assessee,
Correct.
this is the note.
So it is not a case that the assessing officer did not examine this issue.
My lord,
We were under the impression from your argument, because the assessment order was silent on this aspect, the department's contention was that the matter was not examined at all. In fact, in the show cause notice, we're referring to the audit report, that is the opinion formed by the PCIT, but it is not so factually. Am I correct, sir?
In fact, the notice proceeded on the basis that it was examined, but a wrong decision was taken. In the order which he passes, he says that it has not been looked into. My lord, he's gone contrary to his own notice. I mean, the tribunal has, I'll show, my lord,
always the guideline value. What is the valuation called here? Some places it's called circle rate, some places it's called guideline value. Guideline value, there are a lot of decisions, especially arising out of cases under section 47A of the Stamp Act, where a reference is made to the collector by the registering authority in cases of undervaluation, suspected undervaluation. So they say that is an indicator. The guideline value is an indicator. A willing purchaser, a willing vendor enter into a transaction. There may be so many issues on the property. There may be tenants. There may be a dilapidated building, or the terrain will be a rocky terrain. For making the property fit for, say, industrial use or any other commercial activity or for residential, the property has to be prepared. So therefore, the property will not be valued on the guideline value rate. So in certain other cases, the market value will be more than the guideline value or the circle rate. Then what is your case in that? That is why they refer it to the valuation officer in case of any doubt. Here the AO was satisfied. But whether this 56
My lord.
to 10 will be
My-
applicable to leasehold property.
Yes, my lord. In my, I have found a judgment on this, my lord.
Show, let
My
us see that.
My lord, first of all, may I clarify this note, my lord, thing, my lord? Just once, my lord. I will not take much time, my lord.
Please.
What my lord had referred to page 194. This is in a small letter. So exact same thing is at page 81, my lord.
Yes.
In the assessor's reply.
But I've got copies of that portion of the report now because it's set out by the tribunal. It's not very legible. Can you see at the bottom half, the last witness, the last note, the clause 29B.
They raised this point.
I've raised it myself. Look, in this.
56.2 will not apply.
Yeah, that point was raised by the assessee, my lord.
Yeah. Please show that some
Judgment, my lord. Without veneers, it's a Bombay High Court judgment, my lord. Here, my lord, this judgment is on section 50C. So same principle will apply to section 56 to 10.
But this is 50C.
So equivalent.
No. The scheme is different.
My lord, the 50C is for invoked for seller, my lord.
See, it says where the consideration received or accruing as a result of the transfer by an assessee of a capital asset being land or building is less than the value adopted. So the transfer, you go to the definition of transfer.
Section 247.
It is very wide, unlike the definition of transfer under the Transfer of Property Act.
Yes, my lord. My lord, here the relevant.
In fact, tribunal has referred another Bombay High Court judgment, Greenfield. I think that is under 56C.
Greenfield was considered here. No?
Pardon?
Greenfield was considered in Vidarbha, but I've had the advantage of looking.
Oh,
They said that that only dealt with the principle of consistency. In paragraph 8, not dealt with. Last note, 4 lines, 5 lines. In CIT was Greenfield Hotels.
so they say Greenfield of no assistance to the, this case. You got Greenfield, you got?
My lord,
Well, on this question, there is a divergence of opinion, Lord, I must point out. The Honorable Karnataka High Court has taken the view that it only applies to land or building or both, and not rights. And not the Honorable Bombay High Court in this recent view, judgment what has said is.
But if the deed of assignment is virtually a lease in perpetuity, it would be tantamount to transfer.
But transfer it will be, because these are not 50C, 56, 210. These are not provisions to tax something which is which is not changing hands, which is on the basis that these are probably the values which have changed hands. Whereas not,
In fact, that issue need not be gone into.
yes, in my submission, it's not necessary in the facts of this case. I would be submitting it's not necessary to go.
What is the substantial questions of law suggested?
my lord. Page 10, my lord.
You have not raised that issue regarding whether 56 C 210 will apply to leasehold property, though the tribunal gives such a finding. We will not go into it. If there is a divergent view,
Yes,
that need not be, and they have not raised it as.
My lord, in that not particular fashion, but as a ground 3 point, ground 3, my lord. It's in ground 3, my lord.
That is also on valuation. No, the question has not been raised to the effect that 56 210
Yes,
will not be applicable to a leasehold property.
my lord, there's a decide the issue relating to application of section 56 to 10 of the Sect Act on acquisition of leasehold property.
No, you read the
Yes, my lord.
full sentence. By not considering 56 to 10 of the Act introduced in Finance Act was applicable for the assessment year. So this is on the ground that because the tribunal gave a finding that the transfer took place in 2016, not in the year under consideration. For that you have raised this ground.
Both, my lord, in respect of both,
We will
my
not go
lord.
into that. Then what is the other one? Writing back of provision.
Writing back of provision. In that respect, my lord, the PCIT has directed the assessing officer to whether that should be allowed or not. To examine only that portion was the finding, my lord.
Where is the, in the show cause notice, which paragraph deals with this writing back? Second issue. In the show cause notice,
It's at page number 42, volume 1 note. The
third paragraph.
third paragraph. Moreover, as per seal number 26.
Hmm. Here also, he doesn't give any finding. Anything else?
And my lord, may I place judgment on that, whether date of transfer, what will be the date of transfer, my lord? Because the tribunal has given a finding on that. Sir. The paragraph 6 and 7 are relevant, my lord.
There was no delivery of possession.
Here, my lord, there is no whisper about when that the possession was handed over in our case, my lord.
Video position, no civil consideration, no registration. Yes.
But they assert in their reply to the show cause also that the leasehold building was acquired pursuant to the agreement of sale dated 31/12/16 and registration took place in the year assessment year 1890. So this was also examined by the AO. But the entire consideration was paid in 2016.
No, partly.
Partly. 15 lakhs or something was.
No, it was substantially paid because the transaction needed the approval of the MIDC because it was government lease. So that after the approval, the deed was executed. And I didn't find the tribunal having taken this point as a basis for granting it. But it's a claim which was made by the
But the tribunal gives a finding that this provision will not apply because the property was acquired in the year 2016.
I'll look for that. And I didn't exactly find it. I'll just look for it again.
I just saw it somewhere.
Yes, my lord, there is a finding, my lord, on this.
How much? 3%. But 50% was paid in 2016.
That was a contention which was raised. No finding.
It was also contention not in my return. So not I didn't that they rested the decision on.
Anyhow, the cost of acquisition is nil. 100% subsidy.
My lord, for that purpose, I had sought my learned friend's help, my lord, on that particular in the morning itself. I have not kindly apprised the court about this because, my lord, I had this incentive scheme 2013. My lord, here I have ascertained that it was a mega project. So for mega project, there is special approval is required from the cabinet. And then now I did not find anything which says that my 100% subsidy is
But tribunal records.
not records, but in the scheme, my lord. That's
I don't know which scheme is it.
It
It
says
says
2013
Maharashtra's
scheme, my lord.
package scheme of incentives 2013.
Yes, my lord. That.
So, mega projects, even a West Bengal state scheme for mega projects, not
Separate scheme is there.
packages there. So that package here was at 110% of the fixed capital investment. So in that fixed capital investment, the cost of the land and building was also taken. The project was a much larger project. The investment land and building was about 265 crore. Then the plant machinery, etc. So the how much? 1600 crore project. So but they said that 110% of that will be granted as subsidy. That was just, that's why it was said that there was nothing for anyone to gain. In fact, whatever I would spend, I would get. So in fact, they stood, if they had shown a higher value, then they would have got
More
better
money.
off.
Anything on facts you would like to?
Yes, I just wanted to show that my lords are pleased to have the show cause notice. It's also reproduced in the commissioner's order. If my lords take the commissioner's order, volume 2, but page 92. I'll just read the relevant part, paragraph 2 on perusal of the assessment record of the assessee. It was observed as under. In the instant case, it was revealed from the audit report of para 2 clause 29b that during the year the assessee has acquired freehold land and building at Ranjangaon, Pune with an agreement value consideration of rupees 88 crores, stamp duty value of which is 177 crore, thus the difference of which is 89 crore, shall be chargeable to tax under the head income from other sources. But the assessee, based on the independent valuation report obtained, claimed that the value assessed by the stamp valuation authorities exceeds the fair market value of the aforesaid property, and therefore the fair market value, that is the agreement value, is the consideration amount, and accordingly no income is to be included under section 56(2)(10), and the same was not added as income from other sources. According to section 56(2)(10), the fair market value is applicable for other than immovable properties. Therefore, there was an income escaped assessment due to the difference between the value of the property determined by the stamp duty valuation by the government authority and the consideration as declared by the assessee to the tune of rupees 89 crore, consequent tax effect of which is 30 crores. So he notes that it's all apparent from the assessment record that the assessee is claimed as an independent valuation report and he faults the assessing officer. Now, I will show how he deals with it finally. Now, kindly also take note on page 93, the paragraph, the second new paragraph. This is regarding the 43B. If I may just explain the background here. In the past, provisions were made which were not allowed as deduction because it was not paid. So those were therefore not subjected to tax in the early years. Number in this year, those provisions were written back. Part of those provisions were written back. This 14 crore odd amount is a provision written back. So this formed a part of the credit to the profit and loss account. Now, provision written back therefore had to be excluded because I had already paid tax on it in the earlier year. So they said, no, this 14 crores you have not paid. You've written it back, but you have not paid. Therefore, you can't get a deduction under 43B. No, this is totally illogical because I have already been taxed on this amount in the earlier years. I'm writing it back. I'm excluding it from my income because I've already been taxed on it. So this is, so this also, now, if I may just read this paragraph, page 93, the second new paragraph. Moreover, as per serial number 26IA of Form 3CD pre-existed on the first day of the previous year, but was not allowed in the assessment of any preceding previous year and was paid during the previous year. Excise duty so much, sales tax so much. The assessee has claimed rupees 28 crores in the computation of income, which includes rupees 25 crores and allowed in the assessment. However, scrutiny of the, this part is important. However, scrutiny of the audit observations, disclosure, comments, and remarks forming part of form number 3C is submitted by the assessee with his return of income revealed that the assessee actually paid during the previous year rupees 10 crore odd due towards sales and other taxes, and an amount of rupees 14 crores 47 lakhs was reversed. As the same is not actually paid during the previous year, the amount of rupees 14 crores required to be disallowed, which was not done in the assessment made under section 143(3). Thus, there was an under-assessment of income to the tune of 14 crores, which resulted in undercharge of tax of rupees 5 crores. So, but this is definitely the definite case is made out that there's a mistake in the assessment. Now, when I give the answer, kindly take the answer which I had given, kindly take at page 79, my lords had seen in volume 1. And I'll draw my lord's attention to the relevant part. So this was on the acquisition of the property. But page 80 background facts are stated. And what kindly similar page 80 paragraph 1.3. In view of the above facts, the company had taken the following view while filing the return of income for the relevant assessment in 1819 or 30th November 2018. The agreement to sell for acquisition of leasehold land was executed on 31st December 2016, that is financial year 2016-17, prior to the insertion of section 56(2)(10) by the Finance Act 2017 with effect from 1st April 2017. The company was therefore of the view that since the property was acquired prior to insertion of the said section, inasmuch as only the registered conveyance was executed in the relevant year, the provisions of section 56(2)(10) of the Act was not applicable to the leasehold buildings acquired. Even otherwise and without prejudice to the above, the purchase consideration paid for the leasehold land was at the fair market value of the building as assessed by the registered valuer, and therefore no addition was warranted under section 56(2)(10). Also, freehold land which was acquired on 6th September 2017 for rupees 13 odd crores was well above the fair market value of the land as assessed by the registered valuer of rupees 12 crores 75. Therefore, no addition was warranted under section 56(2)(10) of the Act. It shall be noted that the tax auditor had also taken note of the above and extensively reported the same in notes to clause 29B of the tax audit report. Now, that if my lords are pleased to have that single page which I handed up, I'll read it for my lords. It's the last part, clause 29B. It says, particulars of amount included under head income from other sources as referred to in clause 10 of subsection 2 of section 56. During the year, the assessee has acquired leasehold land at Ranjangaon, Pune for consideration of rupees 94 crores. The assessee claims that the leasehold land acquired does not fall within the ambit of this section, relying on the ratio laid down in the following decisions. Then what paragraph, the decisions are there, then 2. During the year, the assessee has acquired the following immovable property, being land or building, for the consideration stated thereagainst. Then what they say, particulars of the property, agreement, consideration amount, stamp duty value, as per valuation report. So they mention the stamp duty value which is higher. In terms of the third proviso to section 56(2)(10), the assessee, based on the independent valuation report obtained, claims that the value assessed by the stamp valuation authorities exceeds the fair market value of the aforesaid property, and therefore the fair market value that is the agreement values the consideration amount, and accordingly no income is to be included under section 56(2)(10). So much this was a specific case in the tax audit report where it was mentioned. Then what kindly see at page 81, if I may bring my lords back to page 81. And what these are the notes to which the commissioner himself refers as forming part of the computation of income. But paragraph 1.5. The company had also set out the complete facts in the notes filed along with the return of income, copy of which is enclosed at so-and-so. Relevant extract reads as follows. But may I trouble my lords with reading it? During the financial year 2017-18, certain properties were registered in Ranjangaon, Maharashtra. The stamp duty value of the properties were in excess of the actual transaction value of the properties. Both the purchaser and sellers being listed entities, due diligence was followed in arriving at the price based on valuation report obtained from the registered property valuers. Hence, the assessee of the opinion that no adjustment is required to be made under section 56(2)(10) of the Income Tax Act. Further, the leasehold property comprising of land and building which was registered during the year had been purchased by the agreement dated 31st December 2016, for which part consideration was paid in January 2017. Assessee company is therefore of the view that the provisions of section 56(2)(10), which were inserted only with effect from 1st April 2017, is not applicable to this transaction. And further, it is the date of agreement which is to be reckoned for valuation purposes under the Income Tax Act. The assessee further contends that there is no undue benefit or consideration which has accrued to it. The value adopted by the stamp authorities for registration purpose were based on ready reckoner value, which does not take into account various factors like nature of the land, such as industrial or not industrial, topography of the area, rocky terrain of the land, cost incurred in converting the land into industrial purpose, cost of leveling, construction cost involved in rocky land, etc. In the circumstances, the assessee company disputes the ready reckoner value and contends that such value cannot be taken as substitute or reference value for the properties purchased. Further, due to the effect of demonetization, GST implementation of RERA, the actual market value, transaction value of the property is substantially lower than the ready reckoner rates. Besides, other properties like labor issues, other factors like labor issues, farmers' agitation also had impacted the value of the property in and around the location. In the circumstances, the purchase consideration paid by the assessee based on the valuation reports obtained from the registered values does not call for any interference. Then, the reason why I will trouble my lord with the next few paragraphs is because the commissioner says, the finding of the commissioner is that the assessing of, he says in the notice that it has been, there's a wrong decision. In the order, he says the assessing officer has not looked into it at all, and that I have not controverted that part of the show cause notice. I mean, I will show you in paragraphs, page 82, paragraphs 2.1. From the above, it shall therefore be noted that complete fact and details concerning the purchase of the leasehold building and the freehold land for a consideration which was lower than the stamp duty valuation was justified and explained by the assessee before the assessing officer. It was categorically brought out that the transaction value adopted took into consideration the peculiarities of the property and was as such lower than the value under stamp duty rules. Thus, it shall be appreciated that the AO was aware of the fact that the property was acquired by the company at a value which was lower than the stamp duty value at the time of assessment, and as such, it cannot be held that the AO failed to examine the issue at the time of assessment, being unaware of the issue. As the matter had already been assessed by the AO and conclusion drawn after due application of mine, the present proposal to initiate revisionary proceedings is unlawful. Moreover, had the above explanation not been acceptable, then a reference may have been made to the DVO, by district valuation officer, by the assessing officer. The fact that no such reference was made by the assessing officer to the DVO shows that the above explanation offered by the assessing company, along with the return of income, was acceptable to the assessing officer, and that he had taken one of the plausible views in law. It is imperative to point out that the discretion rests with the AO whether he chooses to refer the matter to the DVO or not. If the AO is satisfied that the valuation undertaken by the assessee, then he may choose not to do so. The legislature has consciously used the words may instead of shall in section 50(c)(2) of the Act. In the present case, as the assessing officer was satisfied with the explanation and documents furnished by the assessee in support of the consideration which was lower in the stamp duty valuation, no reference was made by him. The assessee thus contends that the exercise of revisionary jurisdiction on the issue is completely unjustified. Then, the reference in 2.4 was made to a tribunal decision in Peerless. Tribunal was dealing with a similar case under 53. Assessee had furnished the independent valuation. the assessing officer did not make a reference to the valuation officer, but and accepted the assessed value. But the commissioner sought to invoke section 260. The tribunal held that no, he has taken a view in the matter, and it is not that it was mandatory to refer it to the valuation officer. So, but this was the stand taken. Now, I'm going to kindly see the finding note which the commissioner gives. If I may draw attention to page volume 2, if my lords are pleased to have, we're at page 157. Paragraph 6, where he notes the facts of the transaction. Then at page 158, he keeps on noting the facts. Then in 150, the first new paragraph note, he says the last 3 lines, however, the transfer of both these properties were registered by deed of assignment date 27th March 2018. So for all intent and purposes, the transfer of these properties had taken place on 27th March 2018. The assessee had further purchased certain freehold land that he notes then. Hence, the provisions of section 56 to 10, which was introduced with effect from 1/4/2017, is applicable in the case of the assessee in respect of all these acquisition of properties. The provisions of section 56 to 10 of the Act clearly states that where an immovable property is acquired by a person for a consideration, stamp duty valuation of such property exceeds such consideration by an amount of rupees 50,000, the stamp duty value should be taken as a consideration. In this case, the stamp value far exceeds the agreement value consideration in respect of all the properties mentioned above. The difference should have been chargeable to tax under the head income from other sources. The AO has not considered this aspect during the course of the assessment. And the AO has not made any inquiry on this issue, nor did he issue any questionnaire in this regard. The SSC filed its reply dated 13th March 2023, in which it has not contradicted this fact, not completely contrary to the record. But the tribunal has given the specific findings that my lords have already, and therefore, in view of this, the issue is set aside to the AO that the direction to see whether the provisions of section 56 to 10 are applicable in the case of the SSC and give fresh opportunity of being heard to the SSC. Then on this, the 43B part also, assessee had relied upon the decision in Eveready, but where there were similar facts, right back of provision, and therefore which were earlier subjected to tax. So the assessee cited that case and said, my case is covered by this. Then what he says is paragraph 6.5. With regard to the third issue, the facts of the case and submission of the assessee have been carefully perused. Assessee has cited the judgment of the Honorable Calcutta High Court in CIT vs. Eveready Industries, wherein in a similar issue, the court had given a judgment in favor of the assessee. The matter is set aside to the AO with the direction to see whether the decision in the case of Eveready is applicable to the case of the assessee or not after giving due opportunity of being heard to the assessee. But it does not examine anything. It was very simple. The facts were noted by him in the show cause notice itself. This is the right back of provision. The officers saw it very clearly because it's also in the tax audit report. The show cause notice refers to the entire material on record, the audit observations, what was filed with the return. So these are things to which the assessing officer was alive. Not to say the notice
considered that is actually incorrect.
But to say that, then he should have charged the officer with dereliction of duty. Because every officer has to look at the tax audit report. And if he does not agree with the assessee, it will find place in the assessment. If he agrees with the assessee, in this case, apart from disclosure in the tax audit report, the notes were given with the returns, making it very clear as to why the assessee had taken a particular stand. So now, if my lords are pleased to see, my lords have already seen it. I'll just draw attention to the pages. Kindly take.
The finding starts from 184.
Lordship. Now, the 184 is that part regarding they have acted at the behest of the audit, the assessing audit. Kindly take page on this part. Kindly take at page 192. The last 3 lines. Moreover, these properties were valued on scientific basis as calculated with the registered value of Mrs. So-and-so. We also note that the property acquired with SCC was not fully developed and has uneven surfaces, etc. We also note that the fact qua acquisition of properties as well as valuation of properties as such was fully placed before the NFAC. We also observe from the facts that which were disclosed in notes to tax audit report and the notes to computation of income filed along with the return of income filed before the learned AO at the time of scrutiny assessment, copy of which is available at pages so-and-so, which is extracted below for the sake of reference. My lords have already seen that I placed that part of the tax audit report and with the notes in the forming part of the return. Then with paragraph 16. We also note that the SSC has also furnished the valuation report before NFAC, meaning thereby all the facts were before the JO and the NFAC. After taking into account all the facts of the case, has taken a plausible view and did not refer the matter to the DVO for valuation by not invoking the provisions of section 56(2)(10). Therefore, in our opinion, the learned PCIT is not justified in exercising the revisionary power under section 263 of the Act, setting aside the assessment to the learned assessing officer for fresh examination into these issues. So, on this score itself, the order goes because when it has been looked into and he gives a finding it has not been looked into, his notice was not that there was lack of inquiry. His notice was there's a wrong decision taken. Now he turns around and says he's not looked into it. So the 56(2) gives the proviso that says SSC can, if the SSC disputes the stamp valuation, he can ask the assessing officer to make a reference to the DVO. That is by they refer to subsection 2 of section 50C. But the very fact that such a provision exists in the Act, it shows me that the legislature realizes that stamp value may not represent the fair market value in many cases. Therefore, that opportunity is given to the SSC to object to that adoption of the stamp value as the market value and to say that no, you please have it valued. But once the reference is made to the valuation officer, but once he makes the reference to the valuation officer, he becomes the department's expert. Now, I can contradict that departmental valuation by my own expert valuation. Now, in this case, I had given my expert valuation upfront. So, it was therefore he saw that, and that valuation report. It refers to other property transactions. It adjusts it according to this property, and then they have seen all that. The valuation reports are with them.
And you are satisfied.
Therefore,
and moreover, one more issue they point out, both are listed companies.
Yes, ma'am.
And it can't be said due diligence was not made. And where a subsidy is granted, there is a governmental interference in that. It would have been well open to them also at that stage, right to the registering authority to refer the matter for to the collector. That process they have not done. Any events are 100% subsidy. Here is the question of they don't stand to gain by adopting a lesser one.
Well, it's an anti-abuse provision. So in a case like this, but where it is meant to stop exchange of money underhand. So as my lords have noticed, the tribunal has examined that part. And therefore ex facie the sections.
And in fact, under section 47A, there are a lot of decisions. Stamp Act, there are a lot of decisions on when you can't go like adopt that as a gospel truth. In this, let us assume in this area, 1 square feet is valued at X rupee.
The problem persists every day, my lord.
So it all depends. The approach road, type of the property, for what the property is to be put to use. In some cases, the property will have a building which cannot be put to use for industrial purpose. So it has to be pulled down. So automatically, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket B is directed against the order dated March 6, 2024, passed by the Income Tax Appellate Tribunal A Bench, Calcutta, in ITA number 462/K1/2023 for the assessment year 2018-19. The revenue has raised the following substantial questions of law for consideration. Page number 10 and 11, 1, 2, and 3, and 4. We have heard so also. The assessee, the assessment for the year under consideration, AY 2018-19 was a scrutiny assessment under the E-Assessment Scheme 2019 on various issues, and an assessment order was drawn, and an assessment order dated 22/3/2021 was drawn. The Principal Commissioner of Income Tax, Calcutta 1, invoked his power under Section 263 of the Act and issued show cause notice Where is the show cause notice?
Page 41.
Issued show cause notice dated 30/11/2022. Calling upon the assessee to show cause as to why the assessment order passed under section 143 within bracket 3 of the Act dated 27/2/2021 should not be held as erroneous insofar as it is prejudicial to the interest of revenue. There were three issues in the show cause notice.
5 minutes. 3 is dropped.
Totally, there were three issues
5
which were raised in the show cause notice, of which we are concerned only with two issues in this appeal. Namely, number 1I, applicability of section 56 within bracket 2 within bracket Roman 10 on the acquisition of leasehold land and building. And 2, disallowance of claim under section 43 capital B in relation to reversal or write back of provision for liabilities. The assessee submitted their reply dated 13/3/2023, after which the assessing officer, this PCIT passed an order under section 263 dated 29/3/2023, setting aside the assessment order passed under section 143 within bracket 3 of the Act and directed the assessing officer to pass a fresh assessment order after considering the issues which were discussed in his order dated 29/3/2023. Challenging the said order, the assessee preferred appeal before the learned tribunal, which was allowed by the impugned order, and the revenue being aggrieved has preferred the present appeal. The first aspect was whether first aspect to be considered is whether the power under section 263 would have been invoked. A reading of section 263 would clearly show that unless and until the twin conditions are satisfied, that the assessment order should be erroneous and it should be prejudicial to the interest of revenue, comma, the power under section 263 cannot be invoked. Apart from that, the statute mandates that the PCIT should inquire and be satisfied that the case warrants exercise of its jurisdiction and under section 263 of the Act, and such satisfaction should be manifest in the show cause notice, which is issued under the said provision. The tribunal considered the factual position and found that out of the 5 issues which were raised in the show cause notice issued under section 263, except for 3 issues, the explanation offered by the assessee in respect of the other issues were accepted by the PCIT. Furthermore, on facts, it is clear that the PCIT invoked its jurisdiction under section 263 based upon the not based upon, at the instance of the assessing officer, which was incorrect. In this regard, there are several decisions, some of which have also been referred to by the learned tribunal. And as the legal position is well settled, we refrain from referring to such decisions. Therefore, the finding of the learned tribunal that the that PCIT could not have invoked its power under section 263 solely based upon the reference made by the assessing officer is well founded. With regard to the valuation of the property and whether section 56 within bracket 2 within bracket 10 of the Act would apply, we are required to examine the facts. The assessee acquired leasehold / freehold land and building from Bombay Dyeing. The land was acquired from
Bombay
Dyeing.
Bombay Dyeing and Manufacturing Limited.
And from Bombay Dyeing and Manufacturing Company, a listed company, pursuant to an agreement for sale dated 31/12/2016. Since approval was required from the Maharashtra Industrial Development Corporation, the deed of assignment was registered on 27/3/2018, that is during the assessment year under consideration. The freehold land and building situated at Ranjangang the RANJAN comma Maharashtra was acquired for an aggregate consideration of rupees 168,85, 00, 000, which consideration was calculated on the basis of valuation report from the registered valuer who had valued the land based on the direct comparison method and the building based on depreciated replacement cost method. The freehold land was registered with the local authority who valued the leasehold land and building at 211, 63, 11, 850 within bracket for leasehold interest in land and rupees 147, 57, 26, 950 within bracket for leasehold interest on building aggregating to rupees 364, 80, 38, 000. The freehold land was acquired for a consideration of rupees 13, 56, 79, 600 by an agreement to sell dated 6/9/2017 and the deed of conveyance was registered on 29/9/2017 where the value assessed by the stamp valuation authority was rupees 30, 00, 00, 33, 000. And according to the valuation report, the fair market value of the property was rupees 12, 75, 00, 000. The land and building was acquired for setting up a mega industrial unit, and the government of Maharashtra had sanctioned several incentives, which includes 100% reimbursement for the investment made by the assessee company. It is seen that therefore, the assessee had not gained in any manner whatsoever from valuing the properties at a lower value than the value adopted by the stamp duty authorities. Further, it is seen that the property was valued on scientific basis after conducting due diligence by a registered valuer, the property full stop. That apart, the property was not fully developed and had uneven surfaces, and the assessee had to spend substantial money to enable setting up of the mega industrial unit. It is not in dispute that all these facts were placed before the NFAC, and they were also disclosed in the notes to the tax audit report and the notes to the computation of income filed along with the return of income. And these were scrutinized by the assessing officer. In fact, the learned tribunal has extracted the relevant portion of the notes filed by the assessee before the assessing officer. Therefore, it cannot be stated that the assessing officer did not take into account all the factors and had accepted the plea of the assessee and completed the assessment. Therefore, the PCIT to invoke his power under section 263 of the Act has to apply his mind to the audit report and record his satisfaction that the twin conditions required to be complied with under section 263 have not been satisfied. That apart, the Income Tax Act has a provision in has a special provision for full value of consideration in certain cases in section 50 capital C of the Act. The very existence of such a provision is a clear indication that the stamp duty, that the valuation adopted by the stamp authorities is not always sacrosanct, and power has been given for reference to the valuation of authority, where the assessee would also be entitled to contest such valuation, as the said authority is being treated as an expert who on the said subject. Therefore, the tribunal was fully justified in holding that the PCIT could not invoke his power under section 263 of the Act. Though in the show cause notice it is alleged that these aspects were not taken into consideration by the assessing officer, curiously enough, in the order passed under section 263 dated 29/3/2023, the PCIT states that the assessing officer has not considered these aspects during the course of assessment, semicolon. He has not made any inquiry on the issue, nor did he issue any questionnaire in this regard. And also held that the assessee, in its reply dated 13/3/2023, did not contradict these facts. This finding rendered by the PCIT in his order dated 29/3/2023 is factually incorrect and outcome of total non-application of mind. Therefore, the finding rendered by the learned tribunal is fully justified. That apart, while submitting reply to the show cause notice, the assessee has pointed out section 56 2 within bracket 10 of the Act would not apply, as the property was acquired by the assessee pursuant to agreement for sale dated 31/12/2016 and 16 as and on the said date, section 56(2)(10) was not in the statute book, as it was inserted with effect from 1/4/2017. Hence, the order passed under section 263 of the Act was thoroughly flawed. On the second issue, namely, with regard to disallowance of claim under section 43 capital B in relation to reversal or right back of provision for liability, the assessee in their reply dated 13/3/2023 to the show cause notice issued under section 263 of the Act
So that reply on 43B was earlier, page 45,
yes,
13th January, and that relevant portion starts at page
reply
50,
dated 13th January 2023.
at page 57.
Yes.
The substance is paragraph 3.4.
3.1
9.4, my lordship, please, page 59. This is the substance of the.
Um, 13.3. After giving all the relevant facts, contended that the reversal of a provision which was not allowed as an expense when created by virtue of section 43 capital B of the Act, cannot be brought to tax upon its reversal / write back, and such an action would effectively amount to double addition of the same sum, which is wholly impermissible under law. Therefore, the PCAT was required to consider the explanation offered and take a decision in the matter. On the contrary, PCAT, while passing the order under section 263 dated 29/3/2023, miserably failed to render any finding. Despite the fact the assessee placed reliance on the decision of this court in the case of PCAT versus Eveready Industries Limited. Is it reported Eveready?
No, but it says short order, not
With ITAT number 96 of 2017 dated 29/11/2021, and merely set aside the order passed by the assessing officer with the direction to the assessing officer to examine whether the decision in the case of Eveready Industries India Limited would be applicable to the case of the assessee or not, after giving due opportunity of being heard to the assessee. The manner in which the PCAT has dealt with this issue is wholly untenable, and therefore the learned tribunal was justified in setting aside the order passed by the PCAT on that scope. Thus, for all the above reasons, we are of the clear view that the learned tribunal was right in allowing the assessee's appeal and setting aside the order passed by the PCAT. In the result, the appeal fails since dismissed, and the substantial questions of law are answered against it. One more matter you call. Yes, Mr. Soman
Actually,
I'm
Bhattacharya.
for the respondent lordship, led by Mr. Abrothos Mujib, this matter. He's
I'm for the appellant, my lord.
Yes.
How much?
I am assisting Mr. Mitra.
How much time you will take, sir?
My lord, this is a short matter, my lord.
Please, so.
My lord, am I audible to you?
Yes, Mr. Mitra, you are audible.
In that case, my lord, may we come back, my lord, on the next day, because it is my lord, an addition on the basis of an unexplained cash credit under section
All
68.
right, you do it tomorrow. Tomorrow
Yes.
we'll stop with this.
Well, deeply blessed.
Grateful.
Serial number 1.
I appear in serial number 1.
Yes, sir.
Lordship, this matter was mentioned yesterday at my instance regarding the hearing. Lordship, it is at serial 45 of the monthly cause list. The issue, Lordship, on the issue of the jurisdiction of the
Jurisdiction of
Bureau of Investigation.
And who will appear? Where is Mr. Siddiqui?
I spoke with my senior Siddiqui, sir. He is okay for Tuesday, Lordships, coming Tuesday.
Okay.
Left the court today for some personal work. So I have
This
taken
next
instruction.
Tuesday for hearing immediately after fresh cases. Yes.
But I am appearing for the Union of India, madam.
Tuesday.
Lord, if your lordship's pleasure is to allow me to make a humble submission before your lordship. Item 2. Item 2.
Number 2.
Lordship, I am appearing here.
Item number 2.
One next. Mr. Siddiqui said Tuesday.
Mr. Siddiqui.
Immediately after fresh case.
Then
item 2.
my lord, I am for the respondent petitioner, my lord.
I am for the Union of
Lordship, respondent number 2 to 5, Lordship, this matter,
Item number I am for the, my lord, respondent petition.
Lordship, I am
present.
Lordship, I am for the applicant. Lordship, I am for the applicant, Lordship. Lordship, kindly take up the matter on Monday, Lordship. I cannot go to court today, my lord. The files are in
Monday is my personal difficulty. Kindly take it up Wednesday, my lord. Monday is personal difficulties.
Wednesday is convenient for all of you?
Yes, ma'am.
May I make one humble submission, my lord?
Yes.
During the pendency of this appeal, my lord, private respondent number 6 initiated probate proceeding in connection with the post-retirement benefit in view of the fact that the wife of the appellant made nomination in favor of her husband. Subsequently, that was corrected and made in favor of her daughter, only daughter, who is private respondent number 6 herein. My respectful submission before your lordship, subject to your lordship's correction, and may I suggest in a way that since the appeal is pending and the probate application is also pending, let it be your lordship's pleasure to dispose of the appeal with the direction, with the liberty to both the parties to move and file appropriate application after the finality of the probate proceeding.
Let them place the appeal because, my lord, I got an order from the single bench. My lord, the entire
Lordship,
order
kindly.
in favor of myself, my lord. The 100% nomination is granted in my favor. So, my lord, let them place the appeal before your lordship in next Wednesday. Thereafter, my lord, decided it.
Lordship, kindly take up the matter
Kindly
on
see the order.
Wednesday. Lordship, perhaps with my lord, I am disputing, my lord. It is not put into the.
My lord, kindly the matter be taken on Wednesday, my lord. And for the respondent number
Kindly
2 to
take the
5,
matter on Wednesday.
Mr. Banerjee is sick since Saturday. He is having fever. So kindly, if the matter be fixed on next Wednesday, my lord.
So you please take note of the submissions made to the Union of India and then respond to that submission. He says that the nomination has been revised and the 6th respondent has filed a probate application.
Yes, ma'am.
In which these people are respondents.
Yes, ma'am.
So therefore, there should not be inconsistent orders.
In fact, the will was executed by the.
We will adjourn, sir. Mr. Haldar, we will adjourn the matter to Wednesday. You please hear the submissions made by the learned advocate for the Union of India that your client is also a party to the probate proceedings. On Wednesday, you reply.
Yes.
Wednesday.
Grateful, Lordship.
Immediately after fresh cases.
Regarding
Serial number 3 and
The
4.
pension is pending because pension is nothing is released by the Union of India till date.
That is,
Yes, get
they won't release unless the probate is over, they won't release. Yes.
Serial number 3 and 4.
But who will appear? You're appearing for which
For the appellant, my lord.
appellant in MAT 2293.
Yes, my lord.
And there was a CAN application that was allowed. That
An application has been allowed and their calculation has been disposed of, my lord. In the 1 to 8, my lord. Yes, my lord. I've been asked to file.
Whether the direction to pay the remuneration was complied with?
Yes, my lord. I have submitted the paper book, my lord. Paper book was
So now what has to be, this appeal has to be heard,
Yes,
both the appeals, for a claim regarding enhanced remuneration.
Two aspects, my lord. One is enhanced, but my previous, the original, what was paid to me, that has remained suspended from December 22, my lord, till date, my lord. That is the one aspect. And another aspect is what I've still been in service, but I'm not being allowed to discharge my duties, my lord. And for which I am nowhere basically at this stage. This is the things, my lord, I beg to be.
Today they have circulated a letter.
Yes, my lord.
Saying that people can't travel. So let it come in tomorrow. Tomorrow under the same caption.
Yes, my lord. Yes, my lord.
Not today.
Get my lord.
Serial number 5.
I'm for the respondent, my lord.
Appellant is not here. All right, not today.
Serial number 6. Serial number 7.
Serial number 6. Advocate Shanti Yatra is for the appellant. Award is not submitted, Lordship. Kindly 7 days time.
All right. Item 6 at the request of the learned counsel for the appellant. List after a week. Item 7 also? No, only 6. 7.
Serial number 7. Serial number 8. Serial number 9. Serial number 10. Serial number 11.
Yes, my lord. Serial number 11, my lord. I appear on behalf of the respondent authorities.
All right. Next.
Serial number 12.
12, my lord. I am for the appellant, and here I only stay can number 2 stay, and
Respondent has been served.
Respondent has been no allotted for advocate or respondent, my lord. Condonation delay has been condoned. Honorable Justice Ananda Bandyopadhyay, only stay here.
You serve notice then.
No advocate allotted for respondent. Only I'm for the appellant insurance
Correct,
company.
madam. If they have served.
After stay, when after stay, my lord, when direction me to prepare paper book, then I serve the paper book to respondent advocate.
Notice is to be served upon the.
And entire awarded amount has deposited before the tribunal court, workman compensation court. This is my challenge.
Where are your grounds?
And grounds is, my lord, no valid route permit, and tribunal take notional income as 6,000, but the prevailing trend, the national notional income in the 2011 less than the awarded amount, and FIR was lodged another vehicle, not accidental vehicle. 3 points. Grounds,
No,
3 points.
In the other matters, same national insurance company, they have raised a question of law, saying that whether the workman compensation commissioner can direct the national insurance company to pay and then recover. We have admitted those appeals. You raise additional grounds. Who's the advocate, Mr. Pathak?
For admission, it is my lord.
You raised the proper grounds, madam.
Rajesh Singh used to appear for.
You tell her the name.
Mr. Rajesh Singh.
List next week. The appellant is granted leave to raise additional grounds.
Respondents are concerned with notices to be served.
In the meantime, you serve notice also. In the meantime, notice shall be served upon the respondent claimant. Adjourn it by 2 weeks.
After service, I will give.
Serial number 13.
I am for the appellant, my lord.
Respondent.
Yesterday he had appeared. Today I don't.
Because they are saying.
Mr. Jayanto Samanto.
All right, we'll say not today. It will come tomorrow.
Tomorrow. Grateful, my lord.
Serial number 14.
14, my lord, I appear on behalf of the writ petitioner respondent, my lord. I may be permitted to file the affidavit in opposition to the application for condonation of delay filed by the appellants.
How many days delay?
144 days, my lord.
Duly explained in the petition itself.
My lord, my humble submission.
If your lordship thinks, my lord, if it is not sufficient, we may file a reply, or your lordship will kindly take it up. Kindly take up the application, my lord. Paragraph 19 to 38, paragraph 19 to 38. We have step by step, we have said all the process which has been followed. I don't have a copy of the opposition, but
He says.
copy opposition.
No. Yes, my lord. My lord, the copy of the opposition was tendered by my clerk to him, to my learned friend. He has. Yesterday. I am told by my clerk.
It must have been tendered to Mr. Uttam Bosak, not to me.
Yes. Uttam Bosak, Mr. Uttam Bosak is the advocate on record. That is why I addressed him.
No, it is.
Just see. Yes.
I am not Mr. Uttam Bosak. এটাই বলছি। appellate side দাঁড়িয়ে আছে appellate Union of India appellate
Only on the punishment the court has interfered.
yes my lord. Degree of
See, it is a scuffle according to the
but that it was a scuffle and yes, your lordship, if your lordship kindly see, two persons were involved and the court was swayed by one argument that it was a scuffle, both of them were there was no provocation, and I will come to that
The other person was also a member of CASF force.
has been removed from surveys, and the appellate order has this. Kindly see appellate order.
But you should have placed this before the learned judge. That was not placed. Otherwise, why the learned? All other points he has held in your favor.
In our favor.
Then you file a review if that was not placed. See, the judge proceeded on a basis. Two people of the force were involved, fought with each other. One was injured, the other man. This man was, so therefore this man was held guilty and he was removed from service. That he says it's disproportionate, reduction to a lower rank can be done, back wages denied. But you should have brought this to the notice of the honorable judge.
Well, even other than
No,
that.
no.
Even
See,
other than
if you have not brought it, we cannot.
not on this, not on this, not on this point. Separate point. The court has said that there was a provocation. Now, my lord, this is specifically why I want to challenge this order, because, my lord, the degree of discipline in case of a CISF will be different from
the normal
blank clerk or something, my lord. If he is so easily provoked, my lord, then, my lord, he cannot be retained in this service, my lord.
Where is the order of removal passed against the other person?
Well, it is in the it is I do not have the copy, but it is specifically mentioned in the appeal, because he has read this issued in the appeal. Page 1. Well, the appeal starts from page appeal starts from page 145.
This point where has he raised?
That is at page 149. Second paragraph, my lord. There is nothing on record in the case file. That is a different issue, my lord.
No, this is on the question
What
of
last few lines, my lord. But he did not do. However, PW3 Constable James was charged under Rule 36 of the CFA for his indiscipline act and involving himself in a scuffle with his senior, that is appellant, and on being found guilty on the said departmental proceeding, he has been awarded a penalty of removal service with 8/1/2004 white order number.
No, where are you reading? Page 149?
Page 149, my lord.
Ah.
149, second paragraph, last few lines, my lord. Last 5 lines, my lord. However, Lordship, can I read from however? PW3.
No, I think
I think
page number is not tallying. Yeah, what is the internal page number?
Internal page is 5, my lord.
Then it is 150.
Continue page 5.
149.
Second paragraph.
My lord.
Second
Second
However,
paragraph.
PW3 constable
However, yes.
was charged under so and so for his indisciplined act and involving himself in a scuffle with his senior, that's appellant, and on found guilty, the said department procedure ordered penalty of removal from service so and so.
And my lord, and my lord, if your lordship have I don't know if you have noticed it in my limitation application, paragraph 22, I have also said this issue was verified at the top. They had asked for records of that proceeding also. This fact was verified by them also.
And whether this Jaibir Singh challenged the order of removal,
that I have to
you find out. Whether any appeal is pending or writ petition is pending.
Well, even otherwise, I will argue, my lord, the punishment which has been awarded should be awarded by the
It is a disciplined force.
authority,
It's
not by the court, my lord. The court will not reduce. Court will send it back, and my lord, that is the law.
Two issues, sir. Two issues will be you will have to argue. One is the level of discipline to be maintained in a paramedical force is paramilitary force is different from any other civil service. Number two is if the other person who is involved in the scuffle has also faced an order of removal, then the finding rendered by the learned judge was wrong. Thirdly, even assuming the court finds the punishment to be disproportionate, whether the court can substitute the view of the disciplinary authority in a writ proceeding. 3 points you have to argue. We will condone the delay. You argue on merits.
And I will be relying on one judgment, my lord. I am giving you a copy.
My lord, we will condone the delay.
May I submit one thing? My lord, there was a quarrel between two employees, including two employees. One is another, and this fellow. My lord, in my humble submission, and it is on record that the quarrel was not held, not caused in the office, nor it was within the duty hours. Not, my lord, it was outside, outside the.
Maybe.
Yes.
If he is a member of the disciplined force, a police force, or a paramilitary force, he is 24/7 a person belonging to the force.
Yes, that is true, my lord. But my lord, the incident happened not in the office, not in the office premises, but in the rest house, my lord. Your lordship kindly appreciate after duty hours the personnel where they take rest in that rest house. So, my lord,
that we will deal with it.
As your
but the
lordship.
learned judge went wrong because he did not consider this aspect that the other man was also punished with an order of removal from.
Yes, set aside the appellate order. Yes, set aside the appellate order. It is presumed that he has.
See, if he has to substitute the punishment, that portion of the appellate order goes. In the appellate order, that has been clearly recorded. There is no discrimination. If you see the finding rendered by the learned writ court, in the present, para 39, in the present case, one employee has been punished for an incident of scuffle while the other was not held accountable. This is wrong.
This renders the judgment.
Entire judgment is gone. And you have not been able to succeed on any of the grounds. That is why, sir, there are a lot of decisions where the level of integrity in respect of a bank official, in respect of a judicial officer, the pedestal is very high. Similarly, a member of either a state police force or a central force, army, navy, anything, any uniform service, the level of scrutiny will be more.
And in my humble submission, my lord, further humble submission, my lord, after appreciating all the pros and cons of the lease, my lord, the learned trial judge has been pleased to observe reducing the punishment. My lord, in my humble submission, that is, my lord, the removal from service that was shockingly disproportionate.
Both are removed from service.
Yes, yes. my lord.
JB also removed, your client also removed. And in all other points, he has held against the petitioner. So when we read up to para 36 is against you. Paragraph 1 to 36 is against. Then he has recorded your submission. Mr. Chakraborty argued that the authority acted unreasonably and impartially by not taking action against the other employee involved in the incident of scuffling. He further argued punishment is imposed is shockingly. This argument is factually incorrect. Please come. This intra-court appeal has been filed challenging an order dated, challenging the order dated 26/6/2024 in WPA 23983 of 2014. The said writ petition was filed by the respondent herein, challenging the order of punishment imposed upon him, namely removal from service, as well as the order passed by the appellate authority and the revisional authority confirming such punishment. The appeal filed by the Union of India and others is time barred, and there is a delay of dash days in filing the appeal. The respondent petitioner has filed their affidavit in opposition, objecting to the prayer for condemnation of the delay. We have considered the averment set out in the application, and we find sufficient cause has been shown for not preferring the appeal within the period of limitation, and the delay is also not inordinate. Therefore, we exercise discretion and condone the delay in filing the appeal application allowed. We have carefully perused the order passed by the learned single bench and also the annexures which have been annexed to the stay petition by the appellant. On going through the order passed, impugned order, we find up to paragraph 36 of the impugned order, all findings have been rendered, all the findings rendered by the learned report are against the writ petitioner. In paragraph 37, the learned writ court notes the submission made by the learned advocate appearing for the respondent writ petitioner that the disciplinary authority acted unreasonably as no action was taken against the other employee involved in the scuffle. The next argument was the punishment is shockingly disproportionate. This argument was accepted by the learned single bench, and it was held that only one employee has been punished, namely the writ petitioner, for an incident of scuffle while the other person involved in the scuffle was not held accountable. This finding rendered by the learned single bench is factually incorrect. This is evident from a bare perusal of the order passed by the appellate authority dated 31/5/2004. Appellate authority, namely Deputy Inspector General, Central Industrial Security Force, within bracket CISF. In the said order, in internal page 5, the following finding has been recorded by the appellate authority. Sir, I'll mark with red pen. From the above finding appears to have not been brought to the notice of the learned single bench. Therefore, the conclusion arrived at by the learned single bench to hold that the writ petitioner alone has been victimized is incorrect. The other person involved in this scuffle, namely Constable Jaibir Singh, was also charged as per under Rule 36 of the CASF Rules 2001 for his indiscipline and involving himself in a scuffle with his senior, who's the writ petitioner, who's the respondent writ petitioner, and on being found guilty of the said departmental proceedings, he was awarded the penalty of removal from service with effect from 8/1/2004 by order dated 8/1/2004. If this is the position, then it goes without saying both the employees, namely the respondent writ petitioner and the other individual, namely Constable Jaibir Singh, have been dealt with departmentally, and similar punishment has been imposed on both of them. Therefore, the finding rendered by the learned single bench, contrary to facts, is hereby set aside. The next aspect which weighed in the mind of the learned single bench is with regard to the proportionality of the punishment imposed. According to the learned single bench, punishment of dismissal or removal from service is a capital punishment, and it is shockingly disproportionate, and it is and defies logic, and therefore has substituted the punishment to one of reduction to a lower grade. The issue is whether this could be done by the learned by a writ court. Firstly, we need to point out that the level of discipline to be followed by a member of a paramilitary force is much higher than that of any other employee who's employed in any other civil service. Therefore, the question of where the scuffle occurred or how it occurred, what precipitated the scuffle, etc., is of no consequence, when admittedly there was a scuffle in which two people were involved, namely the respondent writ petitioner and the Constable Jaibir Singh, and both have been removed from service. Therefore, the question of interfering with the punishment imposed on a person who is a member of a disciplined force / paramilitary force is beyond the jurisdiction of the court exercising power under Article 226 of the Constitution of India. Even assuming the court comes to a finding that the punishment imposed is disproportionate, the procedure to be adopted is to send back the matter to the disciplinary authority for consideration of appropriate punishment instead of a punishment of removal or dismissal from service. In this regard, we refer to the decision of the Honorable Supreme Court in Union of India versus Constable Sunil Kumar, AAR 2023 AC 554. In the said case also, the respondent therein was a member of the CIS, was a constable working in CISF, who was charged of gross misconduct and disobedience of orders in his capacity as a member of the force under Section 11 (1) of the CRPF Act 1949, in that he misbehaved, insubordinated with a deputy commandant and sub-inspector by consuming country liquor while on government duty, and threatened senior officers with dire consequences. On conclusion of the departmental proceedings, he was dismissed from service. The order of dismissal was affirmed by the appellate court, which was challenged by filing a writ petition. The writ petition was dismissed, against which an intra-court appeal was filed, and the division bench set aside the order of penalty on the ground that the misconduct was committed by the constable when he was not on active duty, and therefore the offences committed by him can be said to be less heinous offence which does not warrant extreme penalty of dismissal. With this observation, the division bench of the said High Court directed reinstatement of the said constable in service with notional benefits. The said order was challenged by the Union of India and others before the Honorable Supreme Court. The Honorable Supreme Court pointed out that the disciplinary authority imposed penalty of dismissal after holding departmental inquiry and after following the due procedure as required under Rule 27 of the CRPF Rules 1955 and after having held the charges and misconduct proved. Wherein the charge was he had committed grave and serious misconduct.
I have 6.1 intoxication when
6.3. 6.3 is it?
Where conduct charge was misconduct.
The Honorable Supreme Court referred to the decision referred to an earlier decision in Union of India versus R.K. Sharma, 2001, 9 SEC 592, wherein it was held that in exercise of powers of judicial review, interfering with the punishment of dismissal on the ground that it was disproportionate, the punishment should not be merely disproportionate, but should be strikingly disproportionate. And only in an extreme case, where on the face of it, there is perversity or irrationality, there can be judicial review under Article 226 or 227 or under Article 32 of the Constitution of India. By applying this decision, the court held that the division bench committed a very serious error in interfering with the order of penalty of dismissal imposed on the said constable. This decision in the case of Constable Sunil Kumar within bracket Supra will apply with full force to the case on hand. In the instant case, all the other grounds which have been raised by the respondent writ petitioner have been held against the respondent writ petitioner. Full stop. As mentioned above, from paragraph up to paragraph 36 in the impugned order, all findings are against the respondent writ petitioner. Therefore, the charge which stood proved, based on which punishment was imposed, affirmed by the appellate authority and revisional authority, was not interfered with by the learned single bench. Rather, the learned single bench took an extreme view in interfering with the penalty alone, the punishment alone, when all other points have been decided against the respondent writ petitioner. Therefore, we are of the clear view that the order and direction issued by the learned single bench was beyond the jurisdiction of this court, and an error of law has occurred while doing so. For the above reasons, the appeal is allowed, and the order passed by the learned single bench is set aside, and the punishment of removal of service imposed on the respondent writ petitioner stands restored.
Yes. Serial number 15.
Grateful. Yes, sir.
Lordship, serial number 15. I've been informed that learned counsel Mr. Pratik Majumdar could not come to court today since he's down with high fever. Lordship, I'm kindly praying for a not today.
Not today.
Grateful.
Serial number 16.
My lord, I appear for the writ petitioner respondent.
There is an application for continuation of delay, my lord. I think 26 days delay.
Not opposed.
My lord, that has to be done. And my lord, we want to file a supplementary affidavit. My lord, will your lordship kindly give us leave to do that? I shall serve a copy on my learned
You
friend.
want to bring some documents on record?
Some documents, my lord, which are not there in the petition. Which the documents were there in the trial court.
My lord, I would have made that submission. My learned senior friend has said that, so that solves the problem.
So, my lord, your lordship will kindly fix it on some other day.
A week's time will be sufficient.
Yes, my lord. We shall serve it in course of tomorrow. But the short point involved here is this. the employees who had, my lord, taken VRS and retired, my lord, 9 years ago, my lord, they are coming forward to claim certain benefits under an agreement under which, my lord, which will not be applicable to them because they have already taken the VRS and gone. This is a short point involved. On this very aspect of the matter, there is a judgment of the Patna High Court Division Bench that I shall cite before Lordship. And I think, my lord, I shall get some, my lord, some inspiration from a Supreme Court judgment which also says the same thing. But I shall give the reference to my lordship so that he can know.
You have heard so and so. There is a delay of dash number of days in filing the appeal. As the delay has been properly explained, the same is condoned, application allowed. Para. Leave is granted to the appellant to file a supplementary affidavit to bring on record certain documents which were placed before the learned single bench in the writ petition. You give it after a week. Not next week, the week after.
Take a look.
Let the copy of the supplementary affidavit and annexures be served on the learned advocate appearing for the respondent writ petition. Resignation forfeits all past services.
Lord, may I just take 1 second? Lordship has passed, lordships have passed your lordships already. Lordships will also consider, after my learned senior, my lord, makes his submissions, whether, my lord, the conduct of the employer, this is actually a fight like between a David and a Goliath, whether the conduct whereby and whereunder the employer, after having said previously gives a promise that if this is done with officers, you will get this. That is done with the officers, legitimate exercise comes in that I am also entitled. Later written to them, promises reiterated time and again. Then, during the pendency of the writ petition, calls us for an out-of-court amicable settlement which are brought into record. Possibly those will be the documents to be brought to the supplement. Calls us, we go for the meeting, say in the meeting, the outcome is, the minutes is that your statements are being favorably considered. Reject, no, nothing stated. Writ petition comes up for hearing. During the hearing before the learned single bench, again submissions made, we will again reconsider. Again, pending the hearing, we go for conciliation again. Rejected, comes up and says that this is the. And 3 writ petitions taken up together, one is mine. Contentions are completely different. Orders has been passed analogously with separate things. One appeal pending. The lordship will kindly also take into consideration the subsequent conducts after that. Whether that will, my lord, set this as and make it a fresh one. Lordship.
Next.
Lordship. Well, this will come up next Wednesday.
Not next week, the week after.
Week after that, Lordship.
Yeah.
23rd. I'm deeply obliged. July. 23rd July, August.
Serial number 17. I'm bringing note today.
Not today. Why? Both are here. It is only 3:40. All right, not today.
Serial number 18.
18, may I, Your Lordship, I am for the appellant. But what happened in this case? I have appeared in the CPA, Central Armed Force Police Force Examination 2024. I clear my computer-based examination. Thereafter, I call for physical efficiency test and physical standard test. I passed. Then I called for the detailed medical examination. In detailed medical examination, the medical board found me in 3 grounds. Rejected my candidature. I preferred an appeal. In appellate court, appellate board, review medical board, they found 1 ground I fit and 2 ground assigned for my unfitness. My lord, I challenge that on the ground of that, my lord, for the ground which has been assigned for unfitness, the proper investigation has not been done as per their guidelines. That is my grievances. The learned single bench was admitted my writ application and directed the respondent authority to file the affidavit. My lord, if my affidavit is required in this matter, if for adjudication of the matter, my prayer was that 1 post should be kept vacant because I am assailing my grievances on the based on the basic
ground. There will be a
ground.
lot of vacancies. Don't worry. When you will file the affidavit?
But already we have served. We have affirmed.
Today affidavit
I have received. We will request the honorable court to list the matter next.
Lord, it is already appearing
the
today. It has been taken up.
Today it has been called on. I was there, but nobody was there. Today is the call for.
No, Mr. Kundu, you withdraw this appeal. Otherwise, we have to pass some order. Then the single bench will ask what order was.
Yes, yes, that's right, my lord.
After
that
some arguments, the learned advocate for the appellant seeks leave to withdraw this appeal and pursue the case, the writ petition, which is already running in the list of the learned single bench. The appeal is dismissed as withdrawn with the aforementioned liberty.
I'm great.
Next.
Otherwise, I will face difficulty in the court. Sorry.
Number 19.
19, my lord, I am for the
Lord,
appellant.
Lord, I was appearing for respondent number 4 to 7. Lord, I was appearing for respondent number 4 to 7. Lord, am I audible to your lordships, Lord?
Yes, Mr. Chakravarti, you are appearing for?
Lord, for the Indian Museum authorities. Lord, I was having fever during recess. I came back. Lord, can it be, would you lordship take it up on next week? Is it, Lord,
My lord,
can
may I
make that
submit one
request?
thing, my lord? I do not object to the personal difficulty of any counsel, my lord. The issue is that for the order passed by the Honorable Single Bench directed to file charge sheet within 48 hours, just before my retirement. Charge sheet was filed, my lord, by order of the Honorable Single Bench after 12 years of one incident, just before my retirement, after getting acquittal from a criminal matter. Subsequently, this has been issued. Man, I'm in a difficulty, my lord. Is my land advocate on record for the museum is already there, my lord.
Now, what happened to your petition?
Not my what happened, my lord. May I, ma'am?
Let him proceed, my lord. Let him
What
proceed.
actually
I'll try to
happened, my
assist him.
I'm one employee of Indian Museum.
No, you are the appellant in this.
No, I'm the appellant. I'm the private respondent appellant. What happened, my lord? A third party came before this Honorable High Court, moved a writ petition stating that I have submitted one fake SC certificate. On the basis of the writ petition filed by the third party, an order was passed by the Honorable Single Bench stating that a departmental proceeding should be initiated just 3 days before my retirement. On the same ground, a criminal case was filed. I got acquittal in that particular criminal case just before 2 days.
What is the charge in the criminal court?
Same, my lord. Same.
You produced the document as a forged document.
Lord, they produced a fake caste
Criminal code
certificate.
cannot decide your.
Yes.
Mr. Chakrabarti, wait. Criminal code cannot decide your communal status.
I am on 2 points, my lord, before your lordship. Yes, my lord. I'm on 2 points.
Secondly, whether there was a criminal intent or not, you may succeed. But the fact remains, if the appropriate authority finds that the certificate is a fake document, all benefits which have accrued to you based on the fake
My
document.
lord, I am on 2 points before your lordship. First, whether departmental proceeding can be initiated on the basis of application by a third party.
Yes.
Was my first point.
Yes.
My second point, after 12 years, after order of the Honorable Supreme Court is already there, I can place before your lordship right now. After 12 years, they had the knowledge about the same. They issued a one show cause. I have replied to the same. After that, they didn't proceed. And on the basis of judgment passed by the Honorable Single Bench of this High Court, just before 1 day of my retirement, charge sheet has been issued.
And what does the Supreme Court judgment say?
My lord, kindly. Subsequently, this order was also followed, my lord. In some of them, I'm placing the parent one. But kindly comes to citation of 1990 supplementary Supreme Court cases 738. Paragraph number 4, my lord.
What was the charge against the employee in this case?
My lord, employee of the GST. My ratio I'm placing, my lord. But kindly consider ratio is I'm placing.
Sir, it's a crime against society. A fake community certificate is a crime against society.
It was, my lord.
It is rampant in the state of West Bengal.
My lord, it was.
We have dealt with a public interest writ petition. After we directed verification, as many as 800 certificates were found to be fake. You know,
But I know,
there is another decision.
My matter is
another decision of the Supreme Court where a candidate obtained a fake certificate, got admission into the MBBS course, completed the course with flying colors, applied for post-graduation, once again in the reserve category. He completed his MD. Thereafter, it came to knowledge it was a fake certificate. Supreme Court said he cannot practice as a doctor. He cannot use that certificate. We don't want to cancel.
My lord, issue is totally different in this case. Had I been appointed under SC category, had I taken benefit of the SC certificate, the case would have been different. In the trial court, a specific question was put to the complaint whether any benefit was taken by particular petitioner, whether they has used it. Do you have any document? They said no. Kindly comes to page number 13 once, madam. Page number 13. 1-3. Of the stay application.
Yes.
This is my appointment letter, my lord. This is my appointment letter, and I was appointed in a general category, not any SC category, my lord. First, my lord. Secondly, my lord, kindly comes to page number 39, man.
Yes.
And I am placing, my lord. My 13. Man, extremely sorry, man. Extremely sorry.
39.
Extremely sorry. Extremely. My page number 41, my lord. Cross examination.
Yes.
My lord, I am placing first, second, third, fourth paragraph, my lord. I know that every government employee has one service book. It is fact that in this case, accused person, all are government employees. They should have service book of their office. I never tried to see service book of the accused person. I'm not sure whether a service book contained the particulars of the employee which submitted at the time of getting appointment. That is my point, man. At the time of getting appointment or not. I never tried to ascertain whether the post reserved for SC/ST general caste or it is known to me the said post was general caste or not. But I have showed my appointment letter. Have I been appointed under SC category? It would have been reflected in my appointment, my lord. I have not appointed under SC category. On the same self issue, my lord.
But why did you produce the caste certificate?
My lord, kindly one more thing.
Why did you produce the caste certificate? Probably because of the marks secured. You know how the 100-point rooster operates?
Yes, my lord.
So therefore, if a candidate belong to a reserve category obtains higher mark, he will be accommodated
MRC.
in the
Meritorious
category.
candidate.
But the reserved category post has to be carried forward.
Yes, my lord.
It can't be filled up
Yes,
by any other candidate if no reserved category.
My lord, kindly comes to page number 95 now.
95.
95. I'm extremely sorry, my lord. 95, there is an order. 95. 94. 101, my lord. 101.
94.
101, my lord.
101.
101, my lord. Same issues. Regarding their caste certificate, Indian Museum discovered 3 persons has done the same. Me, this particular Arun Kumar Kashyapi, and another person who left the ward for his heavenly abode. This petitioner was taken up by this Honorable High Court. This Honorable High Court was pleased to stay the departmental proceeding. I'm standing on the same footing, my lord.
Now that writ petition is still pending.
Still pending, my lord.
That is one of the reasons they say they couldn't proceed with your charge memo, your show cause notice. Secondly, in another connected proceeding, stay was granted.
Yes, my lord.
Thirdly, criminal trial was pending till 2024. So this 12-year gap, etc. That's all.
My lord, on 17/7/2028, 18, page number 18, show cause notice was issued to me, my lord. I have replied on the same self issue, a criminal case is pending on 27/2018. After 2018, my criminal case was disposed of in 2014. They were a party to that proceeding.
2024.
They were a party to the proceeding. They never challenged the same, my lord. They never challenged the same. Specific questions were put to them whether I have used the myself.
Let your client be thankful that they have not challenged the acquittal. They would challenge the
Yes,
acquittal.
yes.
Kindly
Yes.
visualize
Once
just 2 days before my retirement, my lord.
to do, sir. You have successfully prolonged the matter.
And my lord, this honorable single bench was pleased to direct the authority, my lord, page 99, my lord. In view of the above, the employer museum shall be liberty to submit necessary charge sheet strictly accordance with law following the procedure later within 48 working hours. And in the charge sheet, my lord, there is not a single point explaining the delay. In the Supreme Order judgment, which I have just
You take a defense.
my
Your
judgment,
judgment, a written
my
statement.
judgment, which I have retired, my lord. On 30th, I have retired. My all retirement benefit, my all benefits are stacked. My kindly visualize the judgment I just referred, my lord. The delay of 10 years in that particular case, it was not explained. And here also the same case, it was not, and same judgment, my lord. I'm not carrying the copy of another judgment, my lord. The same judgment was followed, the same ratio was followed in a recent 2005 judgment. I can give the reference, my lord.
And who appears to the museum authority?
Lord, I
Mr.
appear for the
Rishi is there,
museum
my lord.
authority. Lord, I appear for the museum, Lord.
Mr.
Lord,
Chakravarti,
am I
what is
audible?
his main point? Two main points. One
Yes,
is he has not utilized or gained any benefit out of the caste certificate.
Lord,
Secondly, 12 years unexplained delay.
Thirdly,
Lord,
on the
may I,
application of
may
third
I,
party.
may
Thirdly,
I,
on the application of a third party.
Lord, may I explain that? Lord, he has shown the appointment letter. Kindly come to page 114 and 15. He has not shown these 2 pages. Kindly take 114 and 15.
Yes.
Lord, 114, kindly see at the top, this is the Forma C, Pro Forma C, certificate to be produced by scheduled caste and scheduled tribe candidate applying for appointment to post under Government of India. Now, kindly see what he has said. This is to certify that Pranab Das, son of so-and-so, is belong to community Dhobi. Then kindly take the next page. His service book. Not before the criminal court, we could not produce the service book. Not in the service book, it is scheduled caste. His fingerprints are there. His signature is there. My lord knows Captain M. Paul Anthony, my lord. It is on the, my lord, preponderance of probability. Criminal court, it was, my lord, proved beyond doubt. He got acquitted because he could not produce the service book. And my lord, what Mr. Tiwari is saying on the delay, kindly take page 19 of the application. Lord, I should not say this. 19. I should not say this, my lord. My lord, somebody in the administration was helping him. See what is his response. He said, do not proceed, a criminal case is pending. He successfully dragged it. He successfully, kindly see his response. Can he now come and say before your lordships? He successfully dragged it. It is because of him it was dragged. Lord, my junior is there with a bunch of papers for your lordships kind consideration. There are 2 so-called notices. Initially, he said, I have not done anything. Secondly, he says, kindly do not proceed. There is a criminal case. The erstwhile director agreed to his proposal.
And may I
Said, I will not proceed.
do one more
But
judgment?
I did not interrupt Mr. Tiwari.
Please.
But kindly have a look.
Page number in this?
Yes, not his response. He's kindly taking not entry number. There is a list of date. Kindly see, Lord, there are 2 so-called notices that we issued. First is, Lord, 2015. Then kindly see second reply. If I'm not wrong, we verified it from the authorities. The authorities, the DM said we have not issued it. His first so-called reply, Lord, page 12, 13. Lord, I don't know whether it will tally. I'm so sorry, Lord. Page 12 and 13, first so-called and first reply. 12 is the first so-called, 13 is the first reply. Then again in
18/11/2015.
18/11/2015. My lord. 18/11/2015 is the first so-called. Then, my lord, his reply is at page 13. 3rd December 2015, he replied saying that I have not done anything. Then, my lord, again a so-called notice was issued in 2018. Then this page 19 comes. He says, you are proceeding criminally, please wait. And that is how the entire period was taken. Lord, he consciously put his name in the service book. His fingerprints are there. Lord, whether he has taken.
himself said that he applied for the consent. Continue to at the time.
And where does he say don't proceed? Whereas he said that don't proceed with
Page 19 of the stay application, page 19.
ma'am.
He says that, Lord, I am reading it for your lordships. Against the second show cause notice is reply. Kind attention is invited. Page 19. I'm so sorry, not one line.
Don't proceed. I stated about
One
pendency
line.
case.
Kind attention is
I'd like to
invited.
draw your attention that the
Yes.
above said matter is sub judice bearing GR so and so
Yes.
at
Hence,
CFR.
frequently requested the matter kindly be settled on the basis of the verdict of the Honorable Court. Lord,
And the
he
third ground
himself-
he has raised is
Third party.
just on a third party writ petition, you could not have taken action.
Lord, I tell you, lordships, Lord, I could have
Lord.
taken action on my own. There is no bars. Till the date of retirement, he is my employee. Lord,
Lord,
I should be
2000
deprecated by your lordship that I have not done it earlier.
My 2009
And he should be
Supreme Court
thankful
case
to me.
313, my lord. Paragraph number 9.
2009 SCC volume.
2009 SCC. 2009 SCC 313.
Volume 9.
Paragraph number 9.
No. 2000 volume 9 SCC. 2009. 2009.
No, here it was a public interest writ petition.
Yes, my lord.
PIL.
PIL. Ratio is, my lord, on the departmental proceeding is between employee and employer, my lord. My point. Third party comes in the picture. Third party files a writ petition. An order has been passed in that particular writ petition. In a service matter, a third party is entering, my lord.
There, the Ranjit Prasad, who was a practicing advocate in Patna,
Yes, my lord.
who was not a party to the proceedings before the Central Tribunal, he filed.
But here also, my lord, relation between employer and employee, my lord.
This won't apply.
A relation between employer and employee, a third party is coming to the picture, filing a writ petition, and on that particular writ petition, without raising any affidavit, an order is being passed to.
I would say that is absolutely immaterial who has come up.
Chakraborty,
I
yes,
should be deprecated that I have not taken it earlier.
Within
I should have
48
done it
hours,
long time
and
back.
within 24 hours, charge sheet is being filed. That too after 12 years, my lord.
He is not a busybody. He is a trade union.
Yes.
12 years, my lord. Kindly visualize.
You should have taken care of them.
My lord, 12 years. 12 years. Now, that is the issue. That is vendetta, my lord. That is the issue.
This intra-court appeal is directed against the order dated 23/6/2025 at the instance of the sixth respondent / private respondent in WPA 12749 of 2025. The said writ petition was filed by 3 petitioners. Namely, the first writ petitioner was a registered trade union of permanent employees who are working in the Indian Museum, who was the second respondent in the writ petition. And the second writ petitioner was the assistant secretary of the first writ petitioner trade union. In the said writ petition, they sought for a direction upon the authorities of the Indian Museum and other respondents to forthwith initiate disciplinary proceedings against the appellant herein, who was impleaded as the sixth respondent in the writ petition. The sum and substance of the allegations made in the writ petition is that the appellant had produced a fake caste certificate claiming to be a scheduled caste employee, and therefore action should be initiated against him. The learned writ court, by the impugned order, has disposed of the writ petition by directing the Indian Museum authorities to issue necessary charge proceedings in accordance with law and following the procedures laid down in law within 48 hours from the date of the order, that is 23/6/2025. Challenging the said direction, the appellant has filed the present appeal. We have heard so and so. Primarily, three issues have been canvassed by the learned advocate appearing for the appellant. Firstly, that the appellant did not gain any benefit by virtue of the scheduled caste certificate, as he was appointed as a general candidate, as could be seen from the letter of appointment dated 14th June 1989. Secondly, it is submitted that in the fag end of his career, while he was about to retire, direction has been issued to initiate charge proceedings against the appellant, that too after a delay of nearly 12 years, which remains unexplained. The third ground being that action cannot be initiated by the Indian Museum authorities based upon a complaint or a direction issued in a writ petition at the instance of a third party who has got nothing to do with the employer-employee relationship between the appellant and the Indian Museum. We take up the last issue first. And in support of the argument, the learned advocate for the appellant placed reliance on the decision of the Honorable Supreme Court in Ranjit Prasad versus Union of India and others, 2000, Volume 9, SEC 313. The writ petitioners, 2 in number, cannot be stated to be third parties, as the first writ petitioner is the registered trade union, of all permanent employees who are working in the Indian Museum, and they have a valid registration certificate under the provisions of the Trade Union Act 1926. And the second writ petitioner is the assistant secretary of the registered trade union. Therefore, the writ petitioners cannot be treated to be either busybodies or third parties, but being a trade union consisting of all permanent employees of the Indian Museum, cannot be stated to be would definitely have an interest in the well-being of the institution where they are employed. Therefore, such ground canvassed by the appellant cannot be countenanced, and the same stands rejected. The facts in the case of Ranjit Prasad was entirely different. Full stop. The said Ranjit Prasad were a practicing advocate in Patna who had challenged an order in a disciplinary proceedings initiated against an employee by his employer, and the said advocate was neither a party either before the Central Administrative Tribunal or the State Administrative Tribunal. In such circumstances, the court held that a mere busybody who has no interest cannot invoke the jurisdiction of court, especially by way of a public interest litigation. Therefore, the said decision is factually distinguishable. The next ground raised by the appellant is that there has been a delay of nearly 12 years. It has to be seen as to who is responsible for the delay. And from the documents which have been filed by the Indian Museum authorities by way of a compilation, it is seen that it is the appellant who had delayed the matter. In fact, the appellant, on receiving the show cause notice dated 18/11/2015, submitted a reply in which he has admitted that he applied for a caste certificate to an executive magistrate and got the certificate, and he never had any doubt on the certificate. Subsequently, another memo was issued for which he had submitted a letter, page 19.
Page 19 of the stay application. 18th is the show cause, 19 is the letter.
Another show cause notice was issued on 17/7/2018,
My lord.
for which the appellant sent a reply on 20/7/2018, informing the director of Indian Museum that a criminal case is pending in GR number 10806 of 2016 on the file of the Chief
808.
Metropolitan Magistrate, and requested that the matter, within bracket, show cause notice hyphen office memorandum dated 17/7/2018 bracket close, may kindly be settled on the basis of the verdict of the Honorable Court. Therefore, it is the appellant who was responsible for dragging on the matter, and no delay can be attributed to the Indian Museum authorities. The next contention is that the appellant did not derive any benefit by virtue of the caste certificate which was obtained by him. This aspect has to be taken note of by considering the
15.
Documents which are
Page 115, page 115, 114.
This ground has to be considered by taking into consideration the service record of the appellant. From the service book, it is evidently clear that the appellant has declared himself as a scheduled caste candidate, and the first page of the service book also contains his signature, which has been endorsed, which has been countersigned by the museum authorities. Apart from that, he has also produced a certificate. Apart from that, the certificate in pro forma capital C has been produced, which shows that it is a certificate to be produced by scheduled caste and scheduled tribe candidates applying for appointment to posts under the Government of India. Therefore, for all practical purposes, the appellant represented himself to belong to a scheduled caste community. Above all, the caste certificates are issued in order to alleviate the sufferings of the poor and downtrodden who do not have sufficient means and often are denied equal opportunity. If a certificate is found to be false, then it tantamounts to a crime against society, as a person who is not entitled for the benefits extended to a reserved community cannot be granted such a benefit. Therefore, the manner of appointment can hardly be a ground to state that the appellant should be absolved of the charge. For all the above reasons, we find no good grounds to interfere with the order passed by the learned single bench. Accordingly, the appeal fails and is dismissed. Sorry.
My lord, may I pray for one instance? My time to file reply against the charge sheet had already expired when the matter was pending before.
The time.
I don't oppose to that. Let him file the reply. I don't oppose.
After the above judgment was dictated, learned advocate appearing for the appellant requested that the time for submitting reply to the charge sheet may be extended. The appellant shall submit the reply to the charge sheet within 15 days from date.
And within
15 days from the date of receipt of the server copy of this order.
May I ask for one more instance? Two more actually. First, a compilation has been filed before your lordship by the Indian
copy
Museum.
will be given.
Lord, these documents are part of the charge sheet. These we have already served on it.
All right. If you have one
We'll give another copy.
Or we will give one copy.
And
No, I'm giving.
And lastly, my lord, let the observation made by your lordship shall not have any bearing on.
No, it is made clear that the above observations and findings have been rendered to uphold the decision of the learned single bench. And this will not in any manner prejudice the rights of the appellant to defend the charge sheet which has been issued by in the departmental proceedings.
Madam, may I file the original certified copy?
Original certificate copy kept on record. Yes, stop with
But
this.
extremely,
Yes,
extremely
sir.
grateful, my lord, extremely grateful.
One more matter. Sir. You call that and we'll stop with that.
Serial number 20.
My lord, I am for the Union of India, my lord. Affidavit in opposition is being filed today, my lord. I personally want to do the matter personally, my lord. So I am praying not today, my lord.
Not today.
My lord,
Well,
may I file my reply today?
My lord, my affidavit in opposition and the reply thereto may be kept in record, my lord, and an order may be
All
passed
right.
accordingly, my lord.
Affidavit in opposition and reply thereto have been filed, which is taken on record. At the request of the learned advocate for the respondent, adjourned.
My
Next
My
week.
lord, reply I file.
Reply also take.
My lord, tomorrow, my lord, it's one copy is. My lord.
Oh, one copy. You have to.
Yes.
Affidavit in opposition file, you served copy.
Yes, yes.
Yes,
No,
sir.
we have been served, my lord. We have been served.
All right.
My lord, original and a photocopy, I shall file some.
You file it next
Tomorrow.
week.
Next week.
Next, your lordship will.
When the matter is heard, we file it.
My
My
lord.
lord, my lord.
Obliged.
Much obliged, my lord. Much obliged.
Yes.
My lord.